but the person is in Converse, Texas, and somebody brought him the children. I don't know who brought him the children, and he has the children at the park. Maybe that makes a difference to other people. I don't know. Does that make any difference to you, State? All right. Are y'all ready on Moody?
Yes, John.
All right. Is this still going to be a contested? Martin, is this still a contested on? Oh, you're on it. Is this still going to be a contested? All right. Let's bring Mr. Moody down.
Which there's just one violation.
Yes.
There's a number of things that are alleged. Some things might be true, so my comment we're getting true to some things, not true to other things.
All right, so the only thing he has is a violation of the rules and regulations of GPS, am I correct?
That's correct, yes, Your Honor.
And
so the question is, either he did or he did not.
And part of it is he's supposed to be like 600 feet of the residence, and he doesn't know if that's true or not.
All right, so Vashawn, so what's being said is maybe some of it is true, maybe.
This is where things get serious and messy. GPS violations aren't based on feelings or intentions, they're based on cold, hard data. When the law says 600 feet, it's not offering a rough estimate, it's drawing a firm legal boundary. Crossing that line, no matter the reason, even if it's for the kids, isn't just a bad idea, it's a direct violation of a court order. And in the eyes of the law, that's a major
part of it is not true. It's just a violation of GPS. So the question becomes, is he going to plead true to failure to comply with the rules and regulations of the GPS, and this is a matter of the court hearing explanations, or is this not going to be a plea true?
It's going to be a plea that the GPS rules, if I remember correctly, call for him not to go within 600 feet of the complaining witness. He did go a certain distance for visitation purposes with the children.
Well, either he was within 600 feet or he was not, and then there's an explanation. So do people believe he was
within 600 or not because he was in a park?
All right, did somebody talk to the probation and the GPS officer to see if he was within 600 feet?
We have spoken with them, and they're going to, as a proffer, testify that he was.
All right, so they say they're going to say he was within 600 feet.
So, I mean, if that's what they're going to testify to, then we don't have a way of contesting the.
All right, so who's here on GPS?
Smith.
All right, can you come forward, please? And we're not on the record. I'm just trying to get clarification. Hello, thank you so much for waiting and your patience.
Okay.
So here's my question. I think everybody can agree that he was supposed to be on GPS.
Yes, ma'am.
So that's not an issue. So
confirmed he was within the restricted zone. But now we step into the gray area. Was it deliberate, or was there a valid reason behind it? This is where things get complex. It's time to separate intent from violation and figure out what really happened beneath the surface. If you believe proximity laws should allow for more context and flexibility, drop an A in the comments and let your voice be heard.
How far was he supposed to be away from the complainant?
600 feet.
All right, and are you going to say or testify that he was less than 600 feet?
Yes, ma'am.
Of the complainant?
Yes, ma'am.
All right, so is this going to be a plea of true or not true? And all right, thank you so much.
Yes, ma'am. Thank you.
We still may need you because the 600 feet, where was he located at? That's a bad question.
For 1 hour and 23 minutes and 58 seconds, he was at 7460 Kitty Hawk Road, Converse, Texas. And per his condition, he is supposed to be within or without.
And now, here comes the twist. This isn't just about a GPS ping on a screen, it's about a father visiting his children. So the real question becomes, is this a violation of his bond conditions, or an exercise of his parental rights? That's where things get complicated. The court now finds itself walking a legal tightrope, trying to balance enforcement of restrictions with the fundamental rights of a parent. It's not just law versus violation anymore, it's law versus love. And that's where the stakes get real.
Being 600 feet of 7347 Kitty Hawk.
All right, so let me just see where Kitty Hawk is. Is this a park?
I think it's a residence.
It's a
It's an
residence.
apartment complex with a park nearby.
All right, thank you so much.
Yes, ma'am.
So you're gonna come and say that he was having visitation with children or something?
Yes, with his children.
And state, have you investigated whether he was having visitation with the children?
Not specifically regarding the children, but we did investigate the fact that he breached the distance that he was supposed to be within the victim's residence and therefore violated his condition number 29.
All right, so this is what I'm trying to, yes, technically, this is a violation. He's not supposed to be there. The children, one, was he actually seeing his children? And two, are these the children?
Even if the complainant played a role in arranging the visit, the responsibility still legally falls on him. That's the tricky part. This is where the letter of the law and the spirit of the law collide head-on. One follows strict rules, the other weighs human intent. So who truly bears the blame here? Is it the one who crossed the line, or the one who invited it? Drop your thoughts in the comments. Who do you think should be held accountable in a situation like this?
All right, so did anybody want to call the complainant and say, hey, did he have visitation on this day? Did you allow him to have the children at the park on this day? Because that makes a big difference to the court. It may not make a difference to anybody else, I don't know, but it makes a difference to me if he's not supposed to be within 600 feet, but the person is in Converse, Texas, and somebody brought him the children. I don't know who brought him the children, and he has the children at the park. Maybe that makes a difference to other people. I don't know. Does that make any difference to you, State?
I guess yes and no. No to the fact that he still was on notice of his restrictions, and even if someone brought him the children, he should have known that he's supposed to have stayed the appropriate distance away and maybe found an alternative location that wasn't within 600 feet of the victim's residence. But if the victim is the one who set this up.
So does anybody want to call the complainant and see if they said that? I'm sorry? Okay. Does anybody want to call the complainant and figure out how he ended up having visitation with his children at a park?
You can step under so
All right, just step back. All right, thank you. All right, we're taking our break. Okay. Yeah, you all can swear and we're taking our break though.
Agreed order, and I think my name was called while I was in another court.
And who would that be?
Brandon Diaz.
Court is calling 2024 CR 07421 State versus Johnny Ruiz Jr. Can I have parties announced for the record for the state, for the defense?
Ray Lopez for the defense.
And are you Mr. Ruiz?
Yes, ma'am.
Off the record for a moment.
The case takes a sharp turn. We're no longer talking about GPS violations or custody issues, we're now dealing with a deadly collision. A life was lost, and that changes everything. This isn't a traffic ticket. This is a second-degree felony, and it carries some serious weight, up to 20 years behind bars. Pay close attention, because in an instant, this case went from complicated to critical. The stakes aren't just high anymore, they're life-altering.
Deputy, could one of you all make an announcement for Courtney Sloan?
I did, Your Honor. She's in the hallway.
All right, thank you. All right, we're back on the record. The court will find that the state is in compliance with discovery. Probation, this is an application. Did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented? Did you review court admonishments
Yes, Your Honor.
with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
All right, you're charged with a collision involving death as a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call on the right to remain silent.
Yes, Your Honor.
Did you understand by entering this plea you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication?
Amount of money or time can bring someone back. But in the courtroom, these measures of fines, sentences, restitution, are how the system acknowledges harm and offers a sense of closure to those left behind. It's not about placing a price on life, it's about recognizing the weight of loss. Let's be honest, this isn't only about how many years someone might serve. It's about accountability. It's about making sure actions have consequences, and that justice, in some form, is seen and felt by those affected.
If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine.
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Ruiz, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at a cap of 10 years in the prison. There's a $2,000 fine. The state is opposed to your applications, and there's to be restitution payable to the next of kin. Did you understand that to be the plea?
Yes, Your Honor.
Defense is at the plea.
Yes, Your Honor.
State is at the plea.